all right? And then what you have then, and in this conveyance, I, the mortgagor, have to assign, convey all my rights and interests and title to the mortgagee itself. And then the idea is that this particular transaction, I assign all my right, title, and interest to the mortgagee, and this transfer will be voided only if what? Only if that I subsequently make the payments to the mortgagee. Because the mortgagee lent me the money, I assign all my right, title, interest to the mortgagee, and that's the transfer. And after I make payment of whatever loans, then the mortgage transaction, the chattel mortgage transaction will be deemed voided. All right? And then if you look at that chattel mortgage transactions, there's some limitation there. There's some problems. Because if you apply to intellectual property back in 1790 or in the 1800s, transferring all the right, title, and ownership completely to the mortgagee, then what will happen to the IP owner? You cannot use the IP. If you cannot use the IP in the operation of your business, then which means what? You cannot have your employees, you cannot innovate, you cannot pay back the loan. So therefore, we gotta change that. So some states in the early years decided, we are going to create and make some changes to the practice and the law of chattel mortgages by having a concept called non-possessory interest. And so which means, if I am the mortgagor, I'm going to borrow money from you. But guess what? I'm going to give you a non-possessory, which means you, the mortgagee, you don't have possession of the chattel. If I fail to make payment, you can take it. But the interest here is non-possessory interest, not the traditional complete assignment, complete transfer of title interest in the chattel itself. That's, if you think about it, it's incredible development. Okay? Because even when we're in the 21st century, okay, based on my work at the World Bank, so many countries in the 21st century have a hard time to accept and understand this concept of non-possessory and willing to lend money for non-possessory interest there. And so with that in mind, with that framework in mind, okay, with that framework in mind then, I look at a case back in 1845. And this case is in New York, okay? So I look at this case because I want to find out when in the U.S. history, after the development of non-possessory interest in chattels, when did patents, when in the U.S. history, when did patents, was part of the mortgage transaction itself. So I look at patent mortgages back then. And the earliest case I found is in 1845. Okay? So that's why my talk, 1845 to 2014, the earliest case there. So this particular case, that in the opinions itself, in the opinion, 1845, there's this particular phrase. The patentee, which means the patent holder, the patent owner, the patentee having mortgaged the patent right, okay, continue in the notorious use of it until he became bankrupt. Just this particular phrase alone is incredibly rich. The patent owner in 1845 use patents for the loan, use patent as security for the loan, and yet at the same time, the patent owner was allowed to use the patents in the operation of his business. That's what it says. Continue in the notorious use of it until this particular patent owner here, okay, whatever financial situation that he was in, and after that, he was in bankruptcy. But it showed to us back in 1845, patent was used as security in financing. And so it's not a new concept of using IP as security in financing. It's not new. It's in 1845. Okay? It's not a 21st century idea. No, it's an 1845 idea. Perhaps earlier, but this is the earliest evidence that I found. Okay. Now, look at this picture. This picture shows you the very famous Waterman pen. Waterman pen, the inventor, Mr. Waterman, of course. And he invented this very famous fountain pen type, Waterman. And here is the picture of his invention. Okay. Today, those are Waterman pens. You can find them in luxury stores in Paris, in New York. Some of them cost in the thousands of US dollars. So Waterman pen been around for a long, long time. Why did I decide to look at Waterman pen? What's so fascinating about Waterman is that after he invented the fountain pen, what he did in this particular case here, he invented the fountain pen and he founded a company, the Waterman Company. And what he did, he needs financing. All right? Just like any small businesses, he needs financing. How did he get financing? This is the case in 1891. It's a Supreme Court case. And in this particular case, what did Mr. Waterman do in order to get financing here? And so he himself, the inventor, he came home. He had a discussion with his wife, brilliant woman as well. And they came up with an idea. And what's very interesting about the idea is that he told his wife that, I'm going to assign my patents to you. So he assigned the patent to his wife. And he assigned the patent to her in 1884. She licensed it back to him to use the patent for the operation of the business. Is that clever? And then you say that, okay, what are they doing with this? Guess what? She then went to the bank. She then went to actually this lender. And she said to the lenders that, I have a patent. Here's my name. I'm the new holder of the patent relating to the famous fountain pen. I need financing from you, lender. And the lender says, all right, I'm going to provide you a loan. Back in 1884, look at the amount of the loan, $6,500. Imagine how much is today? $6,500. Factor in inflation, investment. How much do you think $6,500 worth today? This is $6,500 back in 1884. Small loan or big loan? Big loan. It was a big loan. The lender willing to provide financing. $6,500 in 1884. Okay? And so the lender was fully aware that she granted a license to her husband for him to use as well. So that in the modern day, we say, aha, that means due diligence. The lender, before you lend the money, you better engage in due diligence. Due diligence means what? Checking everything, analyzing the risk, understand your rights, whether be subject to something, negotiate it, get a better deal after you identify certain issues. So in this particular case here, she signed these agreements with the lender. And the agreement says it's a conditional assignment. And the conditional assignment, what does it mean? This is back in 1884, the conditional assignment. It says that, you know what? I conditionally assign you the patent. If I don't pay you the $6,500, you can take the patent. That's conditional assignment in 1884. All right. Is this incredible? Can you feel it? Or you say that this is so boring? I found it fascinating. It's fascinating. Okay? And so then the Supreme Court looked at the transaction here. The Supreme Court of the United States looked at the transaction in 1891. And the Supreme Court said, you know what? This conditional assignment, what it is really mean? What it really means, the court say that it's just like the typical chattel mortgage, that the patents are used as security in financing. That's what it means. And the court said it doesn't matter what you name it, conditional or what. In substance, it's a financing transaction where the patents are used as security. 1891. That's what the Supreme Court said. All right. And so then, what's so interesting here is as well, that the Supreme Court say that, you know what, if you look at this transaction very carefully, the court say that both at law and equity, even though it say conditional assignments here, the mortgagee will enjoy this right, this set of rights. And the rights, the court say in terms of equitable, okay? In terms of equitable title and legal title, both are vested in the mortgagee. And so what does this really mean? Forget the legalese for a second. The court recognizing the mortgagee, the lender, in a transaction, this is the Supreme Court, relating to patents used as securities here, that the mortgagee himself has enormous amounts of rights. Be able to, obviously, foreclose, but also be able to bring lawsuits as well. If there's infringement lawsuits out there, this mortgagee will be able to have standing to bring litigation, to enforce the patent rights. Okay? And so now, why am I sharing you with this particular case? This case essentially at the highest court of the United States, paving the way for financing using patents as security. It's clear as clear can be. Okay? Because the prior case I showed you, it was a regional court in 1845. This is the Supreme Court of the United States in 1891. So that's with patent mortgage. So you can see then, let's move forward for a second. So I gave you the development in 1800s. Let's move forward into the more modern time. So if we move forward in the modern times, and you look at copyright mortgages, because I just did with you on patent mortgages. Let's look at copyright mortgages. What was the development of copyright mortgages during this time? And so we look at, when moving forward here, okay? If you look at the history of copyright for a second, you have the printing press, and the printing press allow the reproductions of books, right? The printing press. But then that's boring because it takes a long time, right? So not until that when we move further, okay, into the 20th century, where you see the development of new technologies, and that's when you see new means of distributing content, then that's when copyrights become more valuable. Before that, merely with just the printing press, we are only talking about books. We are only talking about things in paper forms. The distribution was limited, right? And so you look at cases back then, yeah, you can have some copyright used as in mortgages in the publishing industry, but it was limited. And so there's something else as well, right? That the copyright statutes in 1834, there's requirements relating to recording assignment of copyrights. And in the terminology, looking back in the 1834, the provision in amending assignments of copyright requiring the recording of the copyrights, that's a term mortgage is used in the 1834 law. And so what it means that copyright mortgages occurred during that time or before. Definitely before. And then when we move, so recordings of copyright mortgages happening in 1834, we saw that. Like I say, when more development in the distribution of content, exhibiting contents, like for example, okay, motion pictures, in the very early stage of it, that's technologies then, we are talking about different expression. And that particular expression, when you show a movie, a lot of people can see. Versus when you publish a book, if you have one copy book, one person's reading it. And so the development of technology make copyrights more valuable in the sense that be able to use them in financing. So then you see